Okay, well, I'll get going. Let me see what time it is so that 12:02. And this shouldn't, I don't know, this shouldn't take too long today. I wanted to start the year off, and Joan and I should say wanted to start the year off, kind of with some general topics, not diving too deep yet into um contracts. Um, I also want to mirror a lot of what they're going to be doing in Ignite and the bulk of that in terms of like where it would make sense for us to like hop in on or like partnering with or like echoing what they're talking about. Most of those topics are going to be in February. Um, so I'm going to start off with the Code of Ethics this year. Next week, we're going to be doing fair housing. So yeah, so it'll be pretty light today. So thanks again for coming on. Um, and okay, so we'll get into it. So the Realtor Code of Ethics is divided into three parts. It's the duties to the clients and customers, duties to the public, and duties to the realtors. Where you can find the Code of Ethics, if I can get to, so where you can find the Code of Ethics is through the GMAR. So it was adopted and set by the National Association of Realtors and it's enforced through our local board. So in our case, that would be the Greater Milwaukee Association of Realtors. So if you ever wanted to, read the full Code of Ethics, you can download it here by going to their website. And here is the full 8 pages of it all. I'm not going to be going through each standard of practice. I'm just going to be going through each article today. But then there are subsets under each article with the standards of practice that kind of breaks it down even further to kind of explain what each article is about. So, and then in terms of enforcing the Code of Ethics, as I said, we do that through the GMAR. I'm gonna go back to a slideshow here. And in terms of our agents needing to, file an ethics complaint, or go into arbitration over a potential dispute on commission, we would be doing that through the GMAR. So there is a professional standards committee that the GMAR has set, and they intake these complaints. There's a grievance committee that kind of goes over the complaints to see if they're just and if it's something that the grievance committee feels should be pursued. Because there are kind of frivolous complaints that could come in. So it's the grievance committee's job to kind of vet those, I guess is the best way to say that. And then in terms of going to an ethics hearing, there's a number of ways that these complaints can be handled. But usually it's ending up in just an ethics hearing. So, the parties will get together. The GMAR will assign the case to those of us who serve on the Professional Standards Committee. We'll hear it and then, make a decision based off of both sides. So definitely very local process. Your peers are the ones who are hearing these complaints. So, and then, obviously, your compliance broker's roles, so Joan and I, Andrew, we are the ones who will help guide you through this process. So if you guys do have, whether one is brought up against you or whether or not you want to make a claim, um, then we would help you and guide you through that process, okay? Okay, so the first section, duties to clients and customers, so that is Articles 1 through 9. And just getting right into Article 1. Um, so when representing a client, realtors pledge themselves to protect and promote the interests of their client. Obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly. So this comes into our duties, and this should be familiar to you in terms of like, this are in our disclosures, in our agency agreements. We as realtors have an obligation to treat all parties honestly, whether or not they are a client or a customer in the transaction. Pretty straightforward. Article 2, so realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the transaction or the property. Realtors shall not be obligated to discover latent defects in the property or to advise on matters outside the scope of their real estate license. So realtors shall only be obligated to discover and disclose adverse factors reasonably apparent. So, your job here, and I think the best example of this is like when you're bringing a buyer through and doing a showing, we have to point out material adverse facts, right? So your duty here, though, is not to be an expert in these fields. So I think it's just reasonably apparent items, right? So, cracks in foundations, you're going to point those out to a buyer. Um, you're going to point out whether a roof looks old. You can see that with curling, those are good examples of those like reasonably apparent items that, a layman could point out, right? And again, this is another duty to all clients and to all customers. So even if as a customer in the transaction and you don't yet have a buyer agency with somebody, you would still be pointing those kind of things out to a customer. I'll also stop here and say at any time if you guys have comments or questions or yeah, questions. Oh, there's our Joan. Hi.
Hi, sorry I'm late.
Okay.
I was on two telephone calls.
Oh, busy already, getting underway, first of the
Yep,
year.
that's right.
Um, okay, so moving on to Article 3. So Article 3 primarily deals with the distinction between cooperation and compensation. So realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include the obligation to share commission. So I think what they're doing here is just differentiating between the two. So an example here that they have said is that, procuring cause may prevent a buyer's agent from being compensated, but that didn't prevent the act of cooperating in the transaction. So, um, I know this doesn't come up too much, but well, procuring cause claims do, but just in the sense of having the need to differentiate does not come up too much. Article 4, realtors shall not acquire an interest in or buy or present offers from themselves or any member of their immediate family, their firms, or any member without making their true position known to the owner or the owner's agent. So in selling property they own, they shall reveal their ownership or interest in writing to the purchaser or to the agent. So where this is most meaningful for you guys is if you are selling your own home, if you are working with a family member, we do need to disclose that in the private remarks in the MLS. That's point one. And then also that information needs to get transferred into the offer itself. So if you are purchasing, if you're the principal in the transaction, or again, if you're writing on behalf of a family member, you do need to disclose that and put that in the offer to purchase. And then likewise, again, if you're selling for a family member or listing property of your own, we need to put that in the MLS and make sure that the buyer is acknowledging that in the offer as well. Article 5, realtors shall not undertake to provide professional services concerning a property or its value where they have a present or contemplated interest unless such interest is disclosed to all parties. So again, um, you know, this is just echoing Article 4, I think. We just need to make sure that any interest, contemplated interest, is also disclosed. Article 6, realtors shall not accept any commission, rebate, or profit on expenditures made for their client without the client's knowledge and consent. This language is built into our agency agreements and our offers now that is included on the last page. So this is covered for you in terms of the obligation to receive consent, to get consent. Article 7, in a transaction, realtor shall not accept compensation from more than one party without disclosure to all parties and the informed consent of the realtor's client. So again, I most immediately think of the buyer agency contract, where again, that language is built in for us in terms of allowing us to receive compensation from more than one party. And that's under the commission section. Article 8. Any monies coming into the possession of a realtor in trust for other persons, such as escrows, trust funds, clients' money, shall be kept in a special account in an appropriate financial institution. So these are, our trust fund accounts set up already for us through KW. There's just a requirement that any money that we receive, we need to put into our trust accounts.
Steph,
Yes,
can you hear
Amanda.
me?
Yeah.
I'm sorry, Crystal and I were just discussing the last rule. You said, I think, number 7, that
Yes.
realtors cannot accept commissions from both sides.
From
How does-
multiple parties. Where is it? So it's
does that rule not include, like, if you have a buyer agency agreement that says that they should make up the difference in commissions?
nope. So that's what I was kind of saying with that language, that consent language is already built into our buyer agency
Oh,
agreement.
okay, I missed that part. Okay.
Yeah. So it's realtors shall not accept compensation without disclosure and the informed consent of the client. So we are
Without, okay, if I would read the rest of the sentence, then it would be fine. Okay.
So we're good. So yes, you absolutely can. And we're getting that consent in the buyer agency agreement.
Okay, Swanky, thank you.
Yep. Okay, Article 8 or 9, now we're on 9. Realtors, for the protection of all parties, shall assure that all agreements related to real estate transactions are in writing in clear and understandable language, expressing specific terms and conditions of the parties. Copies of each agreement shall be furnished to each party upon signing. So, this is just furnishing a copy of everything that the client and customer are signing. So, I know that when we execute transactions or documents in DocuSign, a version is automatically sent to the party. We obviously need to be in practice of delivering these executed agreements, when you're receiving them from the other side. So, which we are all in practice of. And I go one step further and I put it in a folder for my clients and I share it with them one last time at closing. Just a good idea. So good habit. Okay. So now to the next section of the Code of Ethics is our duties to the public. So these are covered under Articles 10 through 14. Beginning with Article 10, and this is what I was kind of or what I had mentioned earlier, that we're going to get into this next week under fair housing. So Article 10, realtor shall not deny equal professional services to any persons for reasons of race, color, religion, sex, disability, familial status, national origin, sexual orientation, or gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person based on these categories. Realtors and their real estate employment practices shall not discriminate against any person or persons based on these categories as well. So as I said, we're going to get dive deeper into this next week with Joan at our contract training. Article 11, the services which realtors provide to their clients and customers shall conform to the standards of practice and competence which are reasonably expected in the specific real estate disciplines in which they engage. I'm just going to skip ahead here. So, realtors shall not undertake to provide specialized professional services concerning a type of property or service that is outside their field of competence unless they engage the assistance of one who is competent on such types of property or services. So, we run into this a lot actually in terms of agents wanting to serve clients and help clients with property types or in geographic areas that are outside of our general market or outside of our field of competence, right? So, the best example I can give is, we've got a lot of agents who will come and ask if they could help a buyer with up north property. And while they can, my first question and Joan's first question is always going to be, are you the best person to serve this client with this? And if not, then we should be referring it to somebody who operates and works up there. Same is true for property types. So, we get questions on agents who would like to help a commercial property or help a client with a commercial property. Again, we don't want to inhibit this practice, but you do need to call upon somebody who has experience dealing with commercial property, for example, if this is your first time. So this is something we do take seriously. This is in the Code of Ethics, and our duty to exercise with reasonable skill and care falls under this. We need to make sure that we are offering the best services to our clients. And if it's operating in an area that we do know nothing about, that is not operating with reasonable skill and care. So we do, and we will be pushing back if we get those kind of questions, or just, digging deeper and having an understanding or trying to gain an understanding of where you could maybe call upon somebody else or give it away. Okay. Any questions on that? Okay.
It's also a violation of our license law to practice something in which you're not competent. So in addition to the code of ethics, it's also saying your license doesn't want you to practice something where you're not competent.
Okay, and that's even more meaningful in terms of like license revocation potentially.
Right.
So, yes, it's definitely something we have to take seriously. Thank you for that reminder. Okay. Realtors, Article 12, realtors shall be honest and truthful in their real estate communications and shall present a true picture in their advertising, marketing, and other representations. Realtors shall ensure that their status as a real estate professional is readily apparent in their advertising, marketing, and other representations, and that the recipients of all real estate communications are or have been notified that those communications are from a real estate professional. Where this is mostly comes into play is in advertising. We need to make sure that, we've got the KW logo apparent, or one click away. I think that's the kind of like the general accepted guideline around advertising or brokerage. So again, we just need to make sure that we're communicating effectively where we're working. So, okay. All right, something we'll be talking about tomorrow. Article 13. So realtors shall not engage in activities that constitute the unauthorized practice of law and shall recommend that legal counsel be obtained when the interest of any party to the transaction requires it. So we are not attorneys, and there are multiple checkpoints along the way in terms of communication with our clients. where we address this, right? So it's stated in our offers, it's stated in our agency contracts, it's stated in our disclosures, that we are not attorneys and we cannot give legal advice. So if there are issues, again, you're coming to Joan, or Andrew or I, um, and we will help guide you through this. But in terms of communicating with our clients, we cannot, be giving them advice that could be misconstrued as legal advice. Another thing that we need to take very, very seriously. Okay, Article 14. If charged with unethical practice or asked to present evidence or to cooperate in any other way in any professional standards proceeding or investigation, realtors shall place all pertinent facts before the proper tribunals of the member board or affiliated institute, society, or council in which the membership is held. Basically this is saying is, if the GMAR comes forth and asks us for a response to something, asks us for evidence, as it relates to a complaint, that we are going to cooperate. Okay, that should be the last one, in terms of duties to the public. All right, so Articles 15 through 17 are duties to other realtors. So, collegial practices, and the ethics in which we abide by in terms of, relating to our colleagues and other co-brokes. So Article 15, so realtors shall not knowingly or recklessly make false or misleading statements about other real estate professionals, their businesses, or their business practices. Yeah, there's lots of yeah, just be professional and, we're just gonna there's lots of things that can be said about lots of agents. We all work with each other and, it's like, you have a bad experience with a co-broke, and we just, move along. And if there's something that is a violation, um, against the code of ethics, for example, then we would be bringing that to us, and we would, in a professional manner, through the proper means, address that issue, right? So let's keep our mouths quiet. All right, Article 16. Realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. I think the best example of this would just be, we're not to interfere with another agent or another firm's client relationship, right? If there's an exclusive representation, exclusive agency agreement out there already, we cannot interfere with that client.
It's the old term sign jumping.
Okay, yes. Thank you. That being said, I will say, and Joan, I know has experienced this, you might have a client who is coming to you as they are in a relationship that they are not satisfied with or unhappy with, and they might come to you and ask you about what a potential relationship looks like. And we are free to have those conversations about what a potential agreement, agency agreement would look like. But we cannot spark those conversations. It's got to be the client coming to us, if that were the case. So, and we also cannot interfere or give advice on what it would look like to end a agency agreement with another firm. So if that happens, and we get that from time to time, that question, this person's in a listing contract, they're not happy, they want to work with me, what does that look like? So, you're not prevented from having a conversation, you just cannot spark it. or initiated, I should say.
Same with buyer agency.
Yeah. Yep. All right, Article 17, in the event of contractual disputes or specific non-contractual disputes as defined in Standard of Practice 17.4 between realtors associated with different firms arising out of their relationship as realtors, shall mediate the dispute if the board requires its members to mediate. If the dispute is not resolved through mediation or mediation is not required, realtor shall submit the dispute to arbitration in accordance with the policies of the board rather than litigate the matter. In the event clients of realtors wish to mediate or arbitrate contractual disputes arising out of real estate transactions, realtors shall mediate or arbitrate those disputes in accordance with the policies of the board. The obligation to participate in mediation and arbitration contemplated by this article includes the obligation of realtors to cause their firms to mediate and arbitrate and be bound by any resulting agreement or award. Basically, this is kind of the roadmap or just statement that, if there are issues and we need to cooperate in terms of and follow the process of arbitration or mediation. There are checkpoints in place for that, for these issues, and we need to abide by them and be bound by the resulting award or agreement. We're kind of signing up when we're signing up to be on a board. We as realtors have to accept the process and how it is cited or how cases are or client or excuse me or complaints are awarded and just trust and be okay with it. There is appeal process. If someone disagrees with how something was awarded, but we're just basically saying we're signing up for this process by becoming a part of the GMAR or any other board. Okay. And I think that was the last of it. I'm going to go back to, again, the where you can find the full code of ethics. So I summarized each article here, right? But there are standards under each article. So again, like this process when we receive a complaint, or sorry, when the GMAR receives a complaint, part of that process is to like go to the standards of practice and make sure that the complaint lines up with something that can be cited on the standards of practice, right? So when I was saying before that there can be like frivolous complaints being given to the GMAR, their checkpoint is this code of ethics, those standards of practices, and then they'll say, kind of determine whether or not they can go forward with a ethics hearing based off of something found or based off of a potential violation on the standards of practice. So yes, I knew it was going to be quick today, so I could also open it up for other questions. We can answer any other questions pertaining to the code of ethics or anything.
Crystal and I are good. We don't have any questions.
You guys good?
I think so.
Think so? Okay.
I mean, I don't have any questions. I'm good.
Okay, good. Okay. Well, thanks for being here with us. The light load. That's okay.
Next week, fair housing.
Fair housing.
Oh, okay.
Be there or be square.
Exactly.
Bye.